with that, I'm going to invite Gary and Linda to take the stage and proceed. I'm going to put this microphone.
Okay.
All set.
Can you hear me? Yes? Yes? No.
Yep, you should be good. You can talk there.
Talk there. Okay, can you hear me now? You can see how technologically sophisticated I am. This is a real delight for me, and it should really be a delight for you. I've known Gary a long time, and I must say, this is about as much time as anybody can get with Gary, maybe except for his clients. So I want to start with Gary sort of the beginnings. I've got this organized into sort of three parts, the sort of beginning of Gary Bourne, the practice and center of his professional life, and then I have, if we have time, a few questions about what's happening in arbitration, and maybe then the audience will want to ask some further questions. So as everyone has said, Gary's resume and legacy are extraordinary. He's acted as counsel, I think it's over 550 arbitrations, and as an arbitrator in 150 cases. And I know and I'm sure the rest of the audience is very interested in how you sort of got where you are. And so in the beginnings, my recollection, and I've known Gary for a while, is that he grew up sort of in the military. He said once to me, military brat, but I'm not sure that's really true, Army brat. And traveled a great deal and exposed to languages, lived everywhere. He went to Haverford College and the University of Pennsylvania Law School. He clerked for Judge Henry Friendly on the Second Circuit and Justice Rehnquist on the Supreme Court. So, Gary, I wonder about those experiences or exposures that led you where you are today as sort of a renowned counsel in litigation and arbitration, as the esteemed arbitrator that you are.
So I guess the real question isn't how I got here, but instead how I get out of here. As all the experienced counsel in the room know, that sometimes the demands of clients make us on the practitioner side envy Professor Silberman and the others here in the audience from the academic side of the world, and the enviable profession that you lead. I think most of the practitioners in the international arbitration world actually have, like myself, secret aspirations to be on the academic side. And so I think the real question, and in a sense we should flip this interview around probably, I should be interviewing Professor Silberman instead of the other way around. The real question is, how do we on the practitioner side get to the academic side of the divide, where we would be able to design our teaching schedule the way that we want and schedule the classes when we wish. We wouldn't have clients calling us up. Instead, we'd be fixing our office hours and deciding when students or clients got to come and see us. And so I guess the real question is, how do I get out of this position? How do Doak and I and others in the audience get out of the position of counsel and into the position of professor?
Well, I'm not sure that's right. I'm not sure that's right either, because as one looks at you, you did have a sort of fling, right? You taught for a year, full-time at the University of Arizona, and then even with this extraordinary practice, You've taught at what looked to me like universities all over the world, Harvard, Stanford, Penn. I think NYU is not in there, and of course there's a promise, I think, to come and do that. But Singapore, Switzerland, China, everywhere. And you also, of course, have, and everybody knows about this record of publications that probably makes most of us who are academics sort of put to shame that somebody who has that kind of record can produce this kind of work. So did you ever really flirt with the full-time academic career, and what changed your mind to sort of stay in practice, which is, I think, what happened?
Like most flings, this was a youthful indiscretion. The indiscreet part of it, though, was actually after spending a year teaching at the University of Arizona, I decided not to keep doing that and instead to go back to practice. With all seriousness, I do think that the area that we're in, and by that I don't mean Miami, I mean international dispute resolution, is one that uniquely brings together practitioners and academics. This stage is a perfect metaphor, if you will, for that. It is an area where many of those who've written exciting things have come from the practitioner side. One thinks of Jan Paulson and Laurie Craig, whose early work was pioneering in the field. On the other hand, one thinks both of you, Linda, but also Andy Lowenfeld and Hans Smit and others from the academic side who were very involved in the practitioner aspects of the profession. And I think an intriguing question is, why is that so? Why? I mean, certainly there are other areas of both practice and the academy where there's an interchange, but I do think it's interesting that in this particular field there seems to be an especially high concentration of folks with a foot on both sides of the border.
But I mean, if we go back sort of early, to the 80s, transnational litigation and arbitration are not where they are today. And so I just wondered, how did you get your start there, if you can remember? I mean, was there some particular case that you worked on, some particular matter that sort of pulled you there? And it looks like you do a lot of different things, but that's really been the center of the world in which you practice. Was there one thing that sort of pulled you there?
I mean, it's an odd response on my part in a bit, and I'm a little embarrassed on some level in an ITA forum with all our many corporate sponsors to acknowledge this. But the case that really sort of captured my interest for international dispute resolution was Greenpeace. We represented Greenpeace, not exactly the poster child of the month for the corporate sponsors for the ITA, but we represented Greenpeace pro bono in their dispute with the Republic of France. That dispute had arisen out of, I can still remember, many of us can still remember, the sinking of the Rainbow Warrior, the flagship vessel of Greenpeace in Auckland Harbor. And together with Lloyd Cutler, the founding partner of my law firm, we negotiated, and it was oddly the first arbitration agreement that I'd ever negotiated, an arbitration agreement between the Republic of France on the one hand and Greenpeace on the other. I had to deal at an early stage, I was an associate at the time, with issues of capacity, because it turned out there wasn't actually something called Greenpeace. It was a loose collection of about 3 organizations of the sort that one might imagine on Greenpeace's side. And my first responsibility as an associate was getting the signatures and hence demonstrating the capacity of all these various organizations so that the French would be satisfied that they actually had an arbitration agreement. Having negotiated the arbitration agreement and fought viciously over the seat, the wiser heads ultimately persuaded the French to agree to arbitrate in Geneva as opposed to Paris, which they'd insisted for some time. We proceeded with an arbitration, and that process infatuated me. It was a youthful fling in a way that I actually never got
stayed
over.
There.
I never got over that. It demonstrated to me the ability of tailor-made dispute resolution processes to resolve even the most difficult international disputes.
Okay, now I have one question about a substantive issue in which I actually have a great interest, and it relates a little bit to your clerkship with Judge Friendly. David Dorson recently wrote a biography of Judge Friendly that includes a passage about Judge Friendly's interest in the extraterritorial reach of the federal securities laws that were ultimately repudiated by the Supreme Court in its 2010 decision in Morrison. Actually, David told me that you were the one friendly clerk he actually couldn't find or meet in person, but I gather he did talk to you. And then, you know, of course, you have done a lot of work in the international securities area, and you have been quoted, and I sort of found this, and so I'm going to read it. Morrison was the territorial presumption reincarnated in its most unthinking form. So that's what you said about the Supreme Court's decision. So my question is, did you think Judge Friendly was right and the Supreme Court was wrong, or have you got some nuanced way of discussing this?
As usual, Judge Friendly was right. I guess I couldn't say, as usual, this court is wrong. But in Morrison, this court was wrong. In Morrison, of course, as we all remember, the Supreme Court applied a rather rigid view of the territoriality presumption to exclude application of U.S. securities laws to conduct occurring on U.S. territory on the theory that the securities in question were traded on a foreign exchange, and that was the relevant connecting factor, if you will, to which the territoriality presumption was applied. And I continue to think, rightly or wrongly, that that application of the territoriality presumption, like many, is unduly mechanical. I think back to some of the comments that were made in the session we just heard before lunch by colleagues from Asia and elsewhere about the interconnectedness of the world today, about the diasporas and the internet. And it seems to me to apply a rigid presumption of territoriality to interpretations of either U.S. or other statutes in that context just doesn't take account of either the realities of the world we live in today or the sorts of things that would be in Congress's mind as it legislates about that world.
Of course, you're a fan of some predictability and rules and so on, and the problem, of course, of that test as it emerged was one that you had absolutely no predictability about. And so I wonder, sort of as counsel, if at least that kind of a rule in the particular context wasn't sort of desirable. I mean, this is a more philosophical question about the way in which you sort of approach legal rules and legal standards.
And it's an interesting issue, and it's one that your colleague Andy Lowenfeld obviously knows as much about as anyone. But I think, in fact, hard and fast rules like the territoriality presumption aren't really that predictable, because you end up then with disputes about what the connecting factor is, and one can, by recharacterizing different connecting factors, come up with results that are every bit as unpredictable as some sort of balancing test. I think the better course, as Andy suggested in the third restatement, which hopefully will survive the fourth restatement's revisions, is to openly and transparently look at the actual interests and considerations that you're balancing instead of doing it under the cloak of characterizing different connecting factors.
Okay. Let me switch a little bit to your practice in your, what I think, really unique arbitration and practice in your London office. I had the privilege to be there as a program that Gary has set up, or the office has set up, a scholar in residence program, and I hope he'll say a word about that as well. But it's a unique transnational practice in London with, I think it's 5 partners from different countries and associates from all over the world, including some former students of mine who have been there. I've had the privilege, as I said, of witnessing this firsthand as a scholar in residence. So I wonder if you could say a word of how that practice was envisioned and built, and was an office sort of in London an important piece of that practice to be a gateway to a European international arbitration practice and the rest of the world. Now we're hearing, as we heard today, a great deal about China. And then at the end, if you could say a word about the Scholar in Residence program and how that came about. And I'm sure there are people in the room who would love to have the opportunity that I had to spend a little bit of time in that office.
Maybe the easiest thing is to start with the most unique aspect of what you just mentioned, which is the Scholar in Residence program. It's a program whereby academics of all levels of seniority, younger, less young, distinguished, less distinguished, come to our office for a period of time, a month, a few months, to work on matters of mutual interest. Sometimes it involves client matters, sometimes it involves just matters of academic and intellectual interest. It is a program that I'd say is unique at the moment, but it's one that I would hope that our peers in other firms would also find useful. In that regard, our practice in London, although, as you rightly described, is very international, it's not itself unique as compared to that of our competitors. Other firms, whether it's Freshfields or King & Spalding or Herbert Smith or what have you, also are in this particular field especially international. You look at almost all the major arbitration practices, and they're highly diverse. They're diverse both in terms of gender, but also in terms of nationality and language and cultural orientation. And the reason, to some extent, is a reflection of the sorts of disputes and clients and issues that you face. Increasingly, you can't address serious international disputes unless you can bring multiple, not just languages, but legal cultures and expertises to bear. And again, going back to the sessions we had before lunch, it is a reflection of what it is that clients and dispute resolution demands.
Okay, I want to come back to the Sudan and the public, international arbitration that was so prominent. But you've acted as counsel maybe more often in a number of high-profile international commercial arbitrations and some investments as well as transnational litigations. And so I was curious about the way in which, when you are as counsel, you put together materials for an international commercial arbitration as compared to more traditional litigation. Is there a dramatic difference, and what kinds of specific pointers might you give to lawyers who are acting as counsel in arbitration? I know there are highly skilled lawyers who have often talked to me about, well, I don't like arbitration. It's really so different than litigation, and I'm not quite sure how to run that case. And so I wonder what kind of advice you might give. Is it the same? Is it very different?
One has to look at the question on different levels. On one level, there's no difference between litigation and arbitration. You're trying to persuade somebody or some set of persons to agree with you and not with someone else. And at the end of the day, it's simply a question of telling a narrative in a way that convinces someone. On other levels, arbitration can be, need not be, but can be very different from litigation. We heard before lunch, and of course we all know, arbitrations can be, one of their attractions is they can be tailored to particular disputes, particular sets of parties, and therefore there's no necessary requirement to apply the White Book in England or the Federal Rules of Civil Procedure in New York or elsewhere in this country. Instead, what the rules are vary from arbitration to arbitration and panel to panel. In practical terms, I think the most important thing as an advocate is to always listen to the tribunal instead of to yourself. At the end of the day, you're trying to persuade them not yourself or your client, and listening to what it is they're concerned about and tailoring what you say to what they want to hear is, I think, the most important lesson. I also think, as a rule of thumb, and in general, one should be wary of rules of thumb, but if you can't explain your case to your 6 or 8-year-old child over the dinner table without fudging the facts, if you can't explain your case to your 6 or 8-year-old child, then you've got a real problem. They have to be able to understand it, and understand it in language for somebody of that age in a way that will lead them when you're done, not having fudged the facts, to say, yes, Daddy, you're right.
But I mean, if you're, is there something, is there a key element when you're before a tribunal that you think of as a little bit different? I mean, you obviously, you have, 3 arbitrators. There's going to be, in most cases, limited review, so that in that sense, it's different, isn't it? I mean, you're not making a record for a potential appeal. Aren't there things that you might do that are different? Or is it really the same?
I think on some level it's very similar. I mean, of course, you're right. You're not making a record. Occasionally you try to make a record. Occasionally you try to preserve jurisdictional or procedural objections, although those are usually in cases that are going very badly indeed. For the most part, it is life without a safety net, right? I mean, there is no serious judicial review. And I think, to answer your question, I really do think the most important aspect of what you're doing is to focus on all the members of the tribunal, obviously the chair in particular, but all the members of the tribunal, and listen to what it is that they're concerned about. I think eliciting from them what they're thinking, as opposed to having a black box that you're pitching to, is very important. But I think that an interactive process in which you understand what it is that troubles them about your case and address that directly is the most important aspect of advocacy.
Okay, now maybe this is an unfair question, but since I can't push
Let's
you any
skip it.
harder on that, can you give me an example about what might have been one of your, let's say, worst moments in arbitration, and then just to balance it on the other side, one of your sort of best moments or sort of even best victories, and leaving out the Sudan story for a minute.
That is an unfair question. The best moment, of course, is when you get the award, and it says exactly what you want it to say. There's really nothing like, and in today's world of the internet, most awards arrive by email, and when they arrive, there's a frantic. You can almost hear everybody's computers clackering away as they page down to the dispositive bit of the award. And the really good moment in arbitration is when you see all the claims dismissed when you're the respondent, or the amount of damages you asked for as the claimant being awarded. It's really hard, aside from when you make the phone call to the client to tell them that, it's hard to find a moment that's quite that good. And I haven't really had any bad moments.
Of course not. I'm sorry. I should have known the answer to that question before I asked it. There's been a great deal of discussion about a lot of the entrepreneurial marketing of arbitration venues. We heard a lot about it today as well, but there's New York is setting up, and London, and then it's Switzerland, it's Paris, and Hong Kong, now talking about developing Singapore to show why these are the most desirable places. And I mean, I have a couple of questions about sort of that development. I mean, how has that and why has that happened? I mean, obviously it's a business decision, but maybe more particularly to you, when you're advising clients about choosing an arbitral situs, what kinds of things go into that choice if you're actually designing the agreement, thinking about where to do it?
I mean, you're absolutely right to describe this sort of competition. It has, among different jurisdictions, to serve as arbitral seats. And it's sometimes criticized in the way that sort of development of corporate legislation in different jurisdictions is also criticized. I'm not sure, to be honest, and to state the obvious in a sense, part of the reasons that jurisdictions do this is to attract business for the local bar. It's, that you can see excerpts from parliamentary debates both in the United Kingdom and Singapore and elsewhere where it is quite explicitly said, if we adopt this legislation, it will encourage foreigners to come arbitrate here. They will use our hotels, our restaurants, our stenographer services, and occasionally our lawyers. And that's a good thing for our economy. I actually don't think, perhaps it's not surprising that I would say this, I don't think that's a bad thing. I think one can do good as the same time that one is doing well. And in this case, I think that doing good is providing better infrastructure for international dispute resolution, which in turn enables disputes to be solved more efficiently and expeditiously, and that in turn encourages international commerce, which is a good thing, our respective parliaments and legislatures think. And so I think the competition to improve the legal infrastructure for international arbitration is something that should be applauded. And I actually think, and it raises more sort of challenging questions in a sense about the democratic process, I actually think that the sorts of innovations that one sees in countries like Singapore, where the government is directly involved in updating arbitration legislation.
That was going to be the next question, really.
Without extensive debate, but rather fixing technical problems as they come up, is a very interesting model and, in a sense, challenge to our situation, your situation in this country, where you have the FAA with a distinguished lineage to 1925, but that everybody knows doesn't work all that well, and that everybody would like to replace with something like even the 1985, much less the 2006 UNCITRAL model law, but everybody is afraid to touch because of fears of what your Congress might do to it.
Your Congress, also your Congress.
At this moment.
Thank you very much. But I mean, I know there's been a lot of thought and a lot of work and an attempt to do that, and whether that's sort of realistic, really hard to know. I mean, maybe separating out just a section of international arbitration in a separate section, and maybe that'd be a smaller piece that the Congress could chew off. But it is something, I mean, one can say that makes a difference as to whether or not you're going to arbitrate in the United States or London or Singapore, as you say.
I ducked your last question, which is what I advise clients in terms of a seat, but you, in a sense, brought me back to it. I mean, I think one obviously does look at the legislation in a particular jurisdiction. One looks at the local legal community, the sorts of people that would be available as arbitrators. And I have to say that over the last 10 years, the course of judicial decisions and the lack of legislative improvements in this country does, I think, affect, if not what I say, at least how a lot of foreign companies look at the United States as an arbitral seat.
Now you also sit as an arbitrator, and then you've had sort of all of this role as counsel. I know there's been a lot of discussion about sort of potential conflicts about people who are sitting as arbitrators and then are counsel in different cases. And I just wondered about your experience, not only in particular cases, but have you found it difficult to change sort of roles from being counsel to being arbitrator?
I mean, as with my sort of foot on either side of the academic and practitioner camp, I also, like many others in the field, like a foot on both the arbitrator and the counsel side. And I come out sort of very robustly in favor of that particular posture, not surprisingly. And I think it's very important to pay attention to both the benefits as well as the disadvantages. And there are disadvantages, or at least issues that are raised from double hatting, if you will. The benefits are, I think, very clearly, and this applies across the entire age spectrum, because one needs not just to look at senior practitioners with gray or white hair, but also more junior practitioners. And I think the benefits of somebody both sitting as arbitrator or acting as secretary to a tribunal at the same time that they are counsel are enormous. I think arbitrators in general are better if they are or recently have been counsel, because they appreciate the issues that counsel faces and I think have a better appreciation of how to run the arbitral process. Conversely, I think that counsel are much better if they have recently or are presently sitting as arbitrator. They say many fewer stupid things because they're much less likely to be intoxicated by the adversarial character of the arbitral process if they've recently sat as arbitrator. And I think in evaluating the risks of double hatting, it's very important to see the benefits that produces. There are some areas, I think investor-state arbitration is one, where one has to think carefully about the costs, where if awards are public and if there are a limited number of legal issues which are being addressed, one can legitimately ask whether awards get fashioned in light of positions of counsel who are also serving as arbitrator. But I think one can look at those sorts of issues on a case-by-case basis rather than adopting an absolute presumption, a bit like the territoriality presumption.
I mean, you just raised the issue of investment arbitration, and I know you have moved from commercial arbitration to investment arbitration as well. And my friend and your friend, Andy Lowenfeld, has always said, to me at least, there's very little difference in arbitrating investment disputes and international commercial cases. And I've always thought that was wrong. I've always thought that there was a dramatic difference, that one is in a world that he doesn't like, one is a public law world and one is a private law world. And although I know those are coming together, particularly in the arbitration context, it does seem to me that they are very different. And I just wondered what your perceptions are about that, and whether you think there are real differences, not only in the role of the arbitrator, but of the kind of experience one brings to that role. You've done, obviously, both public and private, so you may be one of the people, as there are others in the room, who have both of those experiences. But is it different?
I mean, it's horrible to have to choose between you and Andy. So maybe
I doubt it. That's a pretty easy choice.
So maybe I'll avoid the choice. I think there are both similarities and differences. And I've said in some other contexts that I think both investment arbitration has learned a lot from and has a lot to learn from international commercial arbitration, but also conversely. I think any time that one has a dispute involving a state, whether it's commercial or investment, it's different than other kinds of disputes. I think one can see that in national court proceedings. One can certainly see it in international arbitration. But states, like it or not, behave differently. They take longer to decide things. They have a different set of interests that often come into play both procedurally and substantively. And that makes the process inevitably different. That's not necessarily a difference between commercial and investment arbitration. It's a difference between arbitration with states and arbitration without states. There are also, though, other differences. Again, the line isn't exactly along the investment commercial axis, but there are differences between arbitrations that are public and arbitrations that aren't public. You can have commercial arbitrations that are quite public, and you can have investment arbitrations that are quite private. The dynamic of a process, though, is very different when somebody can watch you on the web the next day as compared to when it's always going to remain behind closed doors.
But the issues also in investment arbitration tend to be similar, at least. I mean, some of the same questions arise, whereas in commercial arbitration, I mean, they tend to be much more sort of factual disputes, and of course, as you say, most of them are confidential and you don't see them. But doesn't that really change the nature of what's happening in the arbitral process?
And again, I think it's difficult to draw a black and white dichotomy or posit one between investment and commercial arbitration. A lot of investment arbitrations involve as much nitty-gritty factual detail as the most commercial of commercial disputes that describe. And conversely, you can have international commercial arbitrations that turn hardly at all on facts and completely on a single legal issue. You also can have international commercial arbitrations that sort of present the same dreary repetition of the same legal issues as previous arbitrations. One only need think of some insurance arbitrations, for example, and you can see evidence of that. So I think it is difficult to say investment arbitration involves lofty questions of international law. Commercial arbitration involves nitty-gritty trench work in the facts. It's not quite that simple. I think what one can say is that investment arbitration almost always engages sexy issues. And by sexy issues, I mean questions of state sovereignty and the extent to which international law can constrain state actions. And those, although they can be present in international commercial arbitration, very frequently aren't. And I think it is because of that category of issues, sexy public international law issues, that investment arbitration both is very interesting in the academy. It's interesting that many in the law schools that do international arbitration full-time actually focus on investment arbitration. Right. But also, I think it's one of the reasons that investment arbitration, much more than commercial arbitration, has attracted criticism and controversy. I think there are relatively few, knock on wood, relatively few avowed critics of international commercial arbitration as a means of international dispute resolution. On the other hand, whether it's in the Osgood Hall statement or other sorts of critiques, one certainly sees a lot of concern directed at investment arbitration. I think because any effort to resolve the underlying issues would attract somebody's concern.
Okay. I can't move from all the different kinds of arbitration without giving you an opportunity to say a word about the public law, the real public law arbitration you did as counsel representing the Sudan liberation movement against the government of the Sudan before the Permanent Court of Arbitration at The Hague. And I know there's been a lot written about that. A lot of people have seen, some of those hearings on the internet, and they've followed it. But can you tell us just a little bit about how you got involved and why, and then how you've reacted to what has followed, what was an apparent success by your client in the arbitration, and now what, does arbitration work in these kinds of situations?
I got involved because a friend of mine was a close advisor to the SPLMA, and when disagreements between the North and the South arose, attention focused naturally on arbitration as a possible way to resolve those disputes. And not surprisingly, I said I thought it would be an excellent way to resolve the disputes, and assisted in both drafting the arbitration agreement and then handling the arbitration. For a while, it felt as if I was right, that in fact I had wisely counseled warring parties to lay down their arms and pick up their pens or their word processors. And there are certainly moments when one sat in the Peace Palace in The Hague with a sea of Mesoria, the northern tribespeople who were most directly interested from the Republic of Sudan, and a sea of Nakdenka on the other side of the room, and saw them hanging on both counsel's words and the tribunal's words and evidencing virtually no animosity, including when the final award was handed down, one had the sense that arbitration really had worked. Nobody was entirely happy with the result, which was probably more evidence that arbitration had worked. We would have liked everything. The North would have liked everything, and we got rather more than they did, but at least in principle, both sides seemed happy. Tragically, other events intervened, and the award remains unfulfilled. One has to take, I think, a long view of the arbitral process sometimes, just like one has to take a long view of international law and its effect on states' behavior. But if one does take that long view, the award's still out there. It still exerts pressure on, frankly, both sides to respect the boundaries that were drawn. And I guess one can say the jury's still out, but hopefully my advice wasn't entirely wrong.
Interesting, you used the term sort of compromise about that arbitration, which was really very specialized. But one of the things you sometimes do hear, even about international commercial arbitration, is that you are not getting legal decisions, you are getting compromise, and the arbitrators are sort of splitting the baby and so on. And I wonder, I mean, that I understand was a very different kind, the Sudan arbitration, but would you agree with that criticism of commercial arbitration, that what you're really getting is compromise? Not that that's necessarily bad, but that you're not getting a legal decision that you would get in a state or national court.
I think it's a very provocative and very challenging question, and I'm not sure I know the right answer. In the Abiy case, the Sudan case, there was a deliberate and conscious choice by both parties not to agree to arbitration ex aequo et bono, right, and not to give the tribunal authority to render an equitable or fair decision. There was instead a very conscious decision to ask the tribunal to answer essentially an on-off question, a yes-no question. The tribunal found nonetheless a way not to do that. And it may be that that goes without saying, if you will, or in some sense goes even if you say the opposite. It may be that there is an aspect to state-to-state arbitration or quasi-state-to-state arbitration that necessarily assumes compromise, that part of what the parties are trying to do is to bridge their differences, and that inevitably, even if they don't say it or even if they say the opposite, entails an expectation of compromise. I didn't think so. I still don't think so. I think in my experience, for the most part, and this applies in the international commercial world as well, tribunals are expected to and often do render yes-no answers.
Yes, of course.
They often grant all a party's claims, and I'll go back to my answer to your question about what feels really good. What feels really good is, as tribunals not infrequently do, they dismiss all of the claims, or they award all of the damages requested. And I therefore think I don't think it is accurate to say international arbitration, especially international commercial arbitration, is a way to get to a kind of rough justice, that there's a baby splitting aspect that inevitably happens. That is no more true in my experience in arbitration than it would be in front of a jury in the Southern District.
Okay, let me switch. I mean, there's been already discussion about your enormous productivity as a scholar, and I have to say I sit here and just with extraordinary envy, that's all I can say. In addition to the materials you produce for practitioners, you've got a seminal casebook in the area of international litigation, the international civil litigation in U.S. courts, and international arbitration cases, materials, the kinds of things that full-time academics do. And of course, maybe the most extraordinary of everything is your treatise on international commercial arbitration that's already been alluded to and has won numerous awards. So let me first start with the casebook. Steve Burbank credits the very first edition of your litigation book a while ago as important evidence that he says actually established an emerging field of international civil litigation. And the first edition of your arbitration casebook, as I remember, was focused on international arbitration, mostly in the U.S. And then in later editions, it became a casebook on international arbitration in the rest of the world. And here you are, counsel, arbitrator, doing everything else. And so what in the world is the motivation, craziness to establish, to produce, to update, and reconceptualize? And let me just start with the casebooks, because many academics, and I'm sure there are some in the room who would say, casebooks are the absolute drudgery of the kinds of things we do or write. So what made you do a casebook? It's a very interesting, it's a takeoff of a casebook. It's a combination of material and casebook. And for those of you who don't know the book, they are absolutely wonderful. You must look at them. They are reference books. They are teaching books. They are everything. So, but why do you do this?
More youthful indiscretion, at least the original editions. Seriously, it struck me with international civil litigation that there really was a field of practice. I looked around at what other law firms, whether it's Sherman and Sterling or Freshfields or Paul Weiss or what have you, were doing, and it was practicing international civil litigation, yet nobody taught it. It seemed to me a good thing to try to bring that together and enable people to actually study what it was that they were doing. I guess all of this craziness, as you rightly call it, comes out of a desire just to explain, a desire to bring order to a field that looks a little disorderly and to tidy it up.
And then maybe a specific question about the International Arbitration Treatise, which has been characterized as, the words tour de force, incredible work, the arbitration Bible, an undisputed classic. And so, how in the world were you able to put something together like this, which has the breadth and detail that this book has? There is, of course, the legend that you never sleep. But even if you don't sleep, where in the world do you find the time to do this, and how much help did you have from the kind of office that you run, as you mentioned before, and associates who are there with expertise from very different fields? But the book has your hand all over it, and I've read through that book from page 1 to the end, and I just stand in amazement. So I have to say something about it.
Well, it does have my hand all over it, and all the mistakes are mine. And there are a fair number of mistakes I see because I'm in the midst of revising it. The second edition, I'll take a moment for a commercial break. The second edition will be out later this year, and there were a fair number of mistakes in the first edition. Hopefully they'll mostly, not all, but mostly be corrected in the second edition. Having a wonderful team around me, obviously, enables me to do it a lot better than I could otherwise. It's not perhaps quite as good as research assistants at NYU or what have you, but...
Let me tell you, let me have anybody from that office. I'll take them right now.
But I think as with any scholarly effort these days, it's actually never a sole enterprise. It takes a collective effort from a whole lot of people. One person has to sort of conceive it and lead it, but unless there are a lot of people pulling laboring oars, it just doesn't get done.
I want to just make one personal, then I want to ask you a couple of questions about policy arbitrations, but since we were talking about interns and research assistants, I have to say that one of the most fulfilling moments about actually being here is I look around the room, and today two of the people that were on the programs this morning, Jeremy and Stephen, are former students of mine from NYU, and anybody who's ever been a teacher and watches the performance of students who outdo their professor really means that maybe your life's work hasn't been empty. And Ms. Fang, who was not my student, I think, but was at NYU, and I know there are other people in the room who I met last night who are former NYU students, and I know that there are academics from other schools, and I know how you feel when you see these younger people come and perform at the level that they perform, and it's just really fulfilling and excitement. And all I can tell you personally to you how very proud I am, and I just had to get that in. So now, Gary, I have a couple of just policy issues that I'd like to ask you about, and then maybe the audience has some others, because I've monopolized a lot of this conversation. But notwithstanding my time at Wilmer, this is the most time that I've had actually one-on-one with Gary, and I'm thrilled to have it. So there are a lot of interesting comments concerning the future of arbitration and a number of suggestions for improving it, and you are not shy about offering your perspectives on a lot of these issues. I've read about them, but so without meaning to constrain you from saying what you want to add more generally about the future of arbitration, I'd ask just a couple of things. One of the suggestions you made had been to elicit something like an industry pledge, whereby parties who are active in transnational commerce would commit to use arbitration as a means of binding dispute resolution in commercial transactions between them. And I guess that means that the pledge would shift the default rule to arbitration at a place to be identified through some particular process. And I guess I would say to you, why should arbitration be a kind of general default rule, and shouldn't clients be making that assessment sort of dispute by dispute or transaction by transaction? And I think there's also been concern that arbitration has been actually pricing itself out of the market with the costs of lawyers, arbitrators, institutional costs. And so, I mean, why should clients now be opting for what is this very expensive, even if in some sense one sees some of the really very favorable attributes about it?
I think the cost of arbitration, like the cost of litigation, is an issue of real concern, and one that is obviously foremost in the minds not just of clients, but also of arbitral institutions and many of the lawyers in this room. It is a very real issue, and it's certainly correct that many of the cases that cost millions or tens of millions of dollars or euros or whatever are cases that deserve that, cases that involve billions of dollars in potential liability, and where the clients on both sides want to spend that money. That said, there are certainly a fair number of international arbitrations that could be run a lot more efficiently, and I think it's a challenge to the arbitral community to be able to address those concerns in a meaningful way, not just talk about it and say you're going to address it, but actually find ways to do things more efficiently. And there are certainly lots of categories of cases where that both can and must be done. The question of what should be the default mechanism. The
pledge issue that I think you've raised, yeah.
Exactly. That question, how, if you have a dispute, an international commercial dispute between two sophisticated parties from different countries that is conceitedly international, what should be the default rule in that case has interested me for some time. The default rule right now is, well, if the parties haven't agreed to arbitrate, consent being the foundation of arbitration, they'll litigate it. And the default rule is you get to litigate it, therefore, in your respective national courts, and given the character
who gets there first.
Not just who gets there first, but who gets there first, and then who's got the most money, and who wants to go off to a third and a fourth and a fifth other country, and who wants to appeal it, and who wants to fight the recognition of the judgments, and my response to that parade of horribles, because trust me, it is, one can see from practice, a parade of horribles that seems to go on, is to say, shouldn't we change the default rule? Shouldn't the default rule, one that parties are free to contract out of, but shouldn't the default rule be international commercial arbitration. And I therefore proposed a pledge, which would, in a sense, not really be a default rule. It would be companies agreeing in principle to arbitrate all of their international disputes with one another, which would entail a sort of consent. I more recently suggested something even more mandatory, if you will, something called a bilateral arbitration treaty. And the concept behind this, and I think is a fitting forum in which to discuss it, would be that two states would agree that all international commercial disputes between nationals of their states would, unless agreed to the contrary, be resolved by international arbitration. The international arbitration would be conducted pursuant to the UNCITRAL rules, and if the parties couldn't agree on an arbitral tribunal, the PCA would select an appointing authority. The arbitral tribunal, pursuant to the UNCITRAL rules, would choose an arbitral seat. Parties would be free to contract out of this, but the presumptive rule in international commercial disputes would be international arbitration as opposed to litigation. And the theory behind that presumption, that default rule, would be that arbitration provides all the things in that context that it does when parties agree by arbitration agreement to arbitrate their disputes. It's neutral, it's efficient, it's in a centralized forum that produces a binding and enforceable result. All of those are good things that enhance international commerce and make it easier to resolve disputes. Litigation in multiple forums with judgments that can't readily be recognized doesn't provide that. And therefore, the default rule should be international arbitration, not national courts.
Okay, this is going to be my last question because I know the audience may want some time. So to me, it looks like you've done everything. Counsel and litigation, all types of arbitration, arbitrator in commercial and investment arbitration, head of a specialized practice in transnational litigation and international arbitration, author of casebooks, treatises, articles, teachers in the best universities of the world. What's left? What's next for Gary Bourne in the years ahead?
I'm staying at South Beach, which I think speaks for itself. Thank you for those questions, though, Linda. They were very provocative, especially the
last one,
which I'm stumped on.
Which you're not answering. Okay. Okay, I'm sure there are lots of other questions, but yes.
Gary, read your first book that you co-authored with David Weston, and just purchased your last book as an ebook. And we've discussed this over the years, but how do you see the role of technology in both in the practice of arbitration and in teaching arbitration, so that you'd have more time to do things that you want to do? I mean, do you see the use, let's say, of iBooks, where you can drill down to videos and connect it to testimony as something that would be increasing in arbitration, or that books that you write in the future could have links to video or to things that would really magnify the learning experience for students?
That's an excellent question, Phil. And I think obviously technology has transformed both the practice of law generally, but international arbitration in particular, but also I think is in the process of transforming the teaching of law and international arbitration in particular.
You can turn on a microphone. It's pretty good.
Yeah, exactly. And I mean, my publisher, Aspen, and others are actively working on delivering products that way. I haven't done it yet, but that's because I haven't focused on it properly. Others have, and I think it offers real promise for the future.
Other questions?
Gary, I'm intrigued by your idea of the treaty, or just the presumption in favor of arbitration, and it just raises a question that I've sort of pondered over the years, which is sort of unique to have your perspective on because of your background in both international litigation and international arbitration, which is the following. Whether there's a presumption or not, there's an increasing amount of international disputes, commercial disputes, and international public law disputes that are being decided by tribunals and therefore being taken out of the hands of the courts. And I'm wondering what your view is on that as a impact on the development of the law and the role of courts, and whether there's some long-term risk, particularly when these decisions are, a lot of them being made confidentially, so we don't have access to them. And what do you think that means in the long term about the law and jurisprudence in general?
Yeah, I've always been sort of less than enthusiastic about arguments that arbitration deprives the world of a public good, namely decisions, public decisions, because it diverts parties into a confidential dispute resolution process that doesn't produce a published decision. If that were true, and some professors, Yale professors, have actually said this, then settlement is also a bad thing. Because settlement is a much bigger threat to that public good of published legal opinions than arbitration is. Folks are going out and settling disputes all the time, sometimes before they even properly arise. And if one really viewed published decisions as a public good, one would want to discourage that. And as we know, in fact, the law does the opposite. It strongly encourages settlement for sensible reasons. I think if there were genuinely a concern, and this focuses in particular on my sort of semi-serious idea about bilateral arbitration treaties, if one were concerned about the absence of published decisions, then one could make the process transparent. If the states that entered into a bilateral arbitration treaty, a so-called BAT, as compared to a BIT, wished they could make that process transparent and open, and they could have the results be published in order to provide guidance to other parties. That's certainly done as well in some specialized arbitration context. In shipping and other fields, awards are published inside the community, in part so they will provide guidance. So I think although I have skepticism about how good the alleged public good is, if it is something people want, there are ways within the arbitral process to deliver it, just as there are ways for the arbitral process to deliver other positive things.
Okay, I've been getting the signal that our time is up. Gary, I want to thank you for your generosity and forthrightness.